excellent discipline. But in recent years, I've taken it a bit further because I tend to know the people I'm having I've been doing it for so long, they've been all doing it for so long, that we actually exchange by email our draft answers. And that hugely cuts down the time because you see, oh yes, we can agree with that, we can agree with that, we can agree with that. And then you can concentrate on the half a dozen things that you don't agree with.
Yeah.
So just taking that idea a little bit further, it does save an awful lot of time.
An excellent idea. Thank you.
You want to do the pitfalls?
We're just going. These are two illustrative pitfalls of holes that experts dug themselves into. The first of them, less well known, although well known to me and to Amanda, is a case that we did together some dozen years ago, involving a personal injury claim by a secretary who worked at Denton Hall, the solicitors, and she acquired a repetitive strain injury as a result of what we said was an excessive workload that she was given. And it was our case that over a short period of time, before she began to experience excessive symptoms and went to the doctor, she had been given far too much to do because the partner for whom she worked on the Partnership Admissions Committee, and there was just a vast amount of additional typing on top of everything else she already had to do that she was made to work on. And we said this was what tipped over, and they hadn't done proper risk assessments and the like. When it came to the joint meeting, the experts agreed a formula which was somewhat confusing, and we were concerned that what had been agreed was far less than satisfactory so far as our case was concerned, because it appeared to suggest that that we had to prove that there had been an increase of work at a time when there hadn't been an increase of work, even on our own case. And so, to clarify this apparent confusion, we put a further set of issues for the experts to consider in a second joint statement. And in this second joint statement, matters got much worse for us, because it was expressly agreed by our expert that if the judge found the facts were as we had pleaded they were, and as our client said they were in her witness statement, then causation was not established. When we received this further joint statement, we plainly were somewhat unhappy, and we contacted our expert and said, well, hang on a minute, mate. How is it that you told us in your original report that on the basis of what our client was saying, that her symptoms were caused by this additional work? And he said, oh, it's terrible. I didn't mean to say what I said in the joint statement. I didn't read it properly. And then he wrote a letter in which he said he hadn't meant to sign up to what he had signed up to, and in fact he thought what he originally said he thought in his original report. An unhappy situation, you might think, for us to go to trial on, but we went to trial on it. And he made matters even worse in the witness box, because he said, oh, it was all because I was pressured on the telephone by the other expert, and it wouldn't have happened if this hadn't happened. It was then pointed out in the cross-examination that there had been no telephone call, that everything had passed by email between him and the other expert. We didn't win the case. We won the case because their expert helpfully conceded in cross-examination that if the facts were as my client set out, and the judge found that to be the case, then causation was established. But I don't think we would ever use the expert again, and anybody who read the report in which he would identify the expert would equally not use it again. And the other rather more famous one is the one that has resulted in the removal of your immunity. Now that is Jones and Caney in 2011. Quite similar, really. The claimants expert was a psychologist. She saw the claimant following a road traffic accident. She diagnosed the claimant as suffering from a post-traumatic stress disorder. The defendants instructed a psychiatrist who saw the claimant, who formed a view that the claimant was deceitful, exaggerating, and had no form of psychiatric disorder whatever. The two experts had a joint meeting. The claimant's expert allowed the defendant's expert to write the joint statement in which he set out only his opinions, that is, that the claimant was deceitful and was not suffering from a psychiatric disorder at all, and she signed it. The claimants then applied to the court for permission to instruct a new expert on the basis that theirs was wholly discredited by her signing a document which she then said she hadn't meant to sign, it hadn't read properly, and she did. The court said, no, you can't have another expert. The claimant then settled the case at a considerable undervalue and sued their expert. And their expert said, you can't sue me, I've got immunity. And it went all the way to the Supreme Court, who said, no, you don't. Yes, the answer is that if you change your mind for no good reason, either because you had not researched your opinion adequately in the first place, or because you are overborne by the persuasive nature of the other expert, or because, as in this case, you simply don't read what the other expert has written in the report, then you will be liable. If, however, you, having prepared entirely properly, you decide that your opinion is different, then you will not be liable. It is only as if you conducted yourself negligently that you will end up being liable. Otherwise, you can rely on the fact that it is your duty to give your opinion to the court, and you would be in breach of that duty were you not to state that you have, on reflection and looking at all the material, decided that the other expert is correct about a particular issue.
So be careful.
Be prepared, as in anything in life.
And just to pick up on that last point, the EWI have an forthcoming event, Betty, where the Jones and Caney case is going to be specifically talked about, isn't it, at the conference?
Yes, at the AGM.
At the AGM, sorry, on
the
the
guest
17th
lecturer
of June.
is actually Lord Kerr, who sat on the panel of the Supreme Court for the Jones v. Caney case. So it's straight from the horse's mouth.
And that's on the 17th of June at the Oriental Club? 19th,
I'm just going to put your...
So, questions now from the floor, please.
Can I just say something about solicitors?
Careful, it's a positive.
Well, they can be quite useful, is the point I was trying to make. You probably remember, David will remember probably, that in the late 90s, when we first started doing expert meetings, there was a great concern amongst claimant solicitors that they were in difficulty if the case disappeared during the expert meeting, because the client would now say, I've been stitched up by one lot of doctors, I've now been stitched up by a second lot of doctors, and they wouldn't understand how the argument evolved. So they were pressing to be able to sit in. And I had quite a lot of experience of solicitors sitting in the early days, and on the whole they behaved very well. But what you do notice is that the presence of solicitors alters the conduct of the experts. And that may not be a good thing, but just occasionally it is. And we had a particularly troublesome expert who behaved appallingly at expert meeting. It wasn't just with me, other colleagues found him impossible. And I, in the end, decided that I would only agree to do an expert meeting with him if the solicitors were present. And it was amazing how it altered his behaviour. He was just like a lamb.
Well,
so they can have their use.
Yeah, no, well, that's a very helpful and illustrative comment, and it's I mean, I find that when I do settlement meetings, often it's useful simply to have the discussion with my opposite number, the barrister, but as you say, sometimes it's quite helpful
Other people being present.
for other
Yeah.
people to be
Yeah.
present.
Yeah.
And that brings us very nicely back to our title, which is Experts Meeting, Know Your Opponent.
That's right. That's right. Yes. Yeah. Be prepared.
Now, I know that, oh, sorry, we've got another question. Yes, I was aware that there was wine there, and I didn't want to get beaten over in the
You brought
rush.
up the title, knowing your opponent. To what extent would you say it's legitimate to go into a meeting, considering that the person you're meeting is your opponent as opposed to your counterpart expert?
This is
Very
an
good point.
adversarial system. He is your opponent.
He is your opponent up to a degree.
He's on the opposite side. He's your
Yeah.
opponent.
He's instructed, but you both have the same requirement, which is to work to the court. So you basically, in the expert meeting, potentially have two people with the same master, and it is hoped that it will draw people together. It doesn't always, and people obviously from different parts of the same profession can have very different views about an outcome. But it gives the court at least the ability to consider the range of views. You know, I sat in on an EWI lecture one evening that was given as part of this educational series, where there was one particular person who said, well, he was a doctor and he gave healing times for ankles for being 3 months if he was working on behalf of the doctor, and 9 months if he was working on behalf of the patient.
War medal.
It's what I would counsel you against if you're in the medical field, and whatever the analogy is in your own field.
So if you give different opinions to your clients, depending on which side they are, you will ultimately be found out. And again, I have personal experience of that, which is painful.
Just a comment, there's an undercover panorama on that subject on Monday night.
Is that?
Yes, 7:30 Monday night.
Well, I'm not part of it.
On exactly what?
An undercover investigation into expert witnesses who act in the best interests of their clients and not the court. What field?
Across a number of fields, or
The website says that it's handwriting, animal behaviour, and CCTV analysis.
Oh,
well, I think the institute should certainly take a copy of the.
Hoping no members are.
Yes, sir.
I've always been nervous since a member of my own profession was criticised for basically giving legal opinion. Always been very nervous about trying to get to sort of overstep the role of the expert and, if you like, get into the role of the court. I've been criticised for doing it in some of the reports I've been doing, which other experts in the field have been commenting on COBs, the financial regulations, and as to whether they've been breached by certain behaviour. I always try and shy away from, if you like, what I think is giving legal opinion, but maybe drawing attention to contrast between various behaviours and the various statutes and regulation. Am I being too timid, or should I be stronger in my?
Well, I can talk specifically to COBs, because
Yeah.
of course COBs is a major part of a lot of work that I do.
Yeah.
And interpretation of actions of either individuals or institutions under the requirements of the regulatory environment is very much a part and parcel of the work of the expert. You know, the biggest part of it is the decision as to whether advice was suitable or appropriate. Absolutely. There are a whole lot of things here. You're not giving legal advice here. You're giving an analysis of, in the shades of grey, as to whether certain things happen.